The challenges of representing someone with mental illness in a criminal case. I received a call about a potential client charged with stalking. The police report laid out the allegations in a way that fit the legal elements of the crime based on the statute and the jury instructions. From a legal standpoint, the case seemed straightforward, but when the client reached out, it quickly became apparent that this would not be a simple case. Before our first meeting, they sent me 6 pages of emails detailing what they believed was the true history of their relationship with the alleged victim. They insisted on scheduling multiple appointments, and I did my best to accommodate their requests. And when we finally spoke, they dominated the conversation, telling me what they thought was important rather than allowing me to guide the discussion with relevant legal questions. Now, they told me to be patient, and I was, but each time I tried to steer the conversation or discussion back to the facts of the case, they became frustrated. They refused to discuss the police report, insisting instead that they were the real victim. And when I asked them direct questions, they avoided answering, raised their voice, and became angry. I understood their frustration. After all, they're facing serious criminal charges. But as an experienced defense attorney, I saw something deeper. I saw signs of mental illness. And again, I'm not a doctor, but I've worked with many clients over the years, and I'm able to recognize red flags almost immediately. There were strong indications of paranoid schizophrenia, delusions, and an inability to engage rationally. A grandiose belief that their own narrative and a complete rejection of any possibility that they could be at fault. And when I inquired about their mental health history, they claimed they had been evaluated but couldn't remember the doctor's name. I asked if they had received a report, medical report, if there were any records I could review, and their response was, "You're not listening to me." They grew increasingly agitated, lashed out, and eventually hung up on me after throwing out some insults and accusations. This was not unusual. Many attorneys would have stopped right there and just moved on, but I have patience more than most, I think, and I know when mental illness is involved. So I tried to talk to them, and these cases are more than just legal battles, they're human struggles. Unfortunately, this client was just looking for a lawyer who would blindly agree with them, someone who wouldn't challenge their versions of reality. They might find such a lawyer at first, hey, yeah, you sound right. But that relationship would eventually break down once the case progressed because the attorney's already got the money. So let's talk about the role of competency in the judicial system and the justice system. One of the most overlooked aspects of criminal defense is competency. Could this client truly assist in their own defense? Could they understand the nature of the proceedings? The answer, in my opinion, is almost certainly no. Again, I'm not the doctor. A competency evaluation would likely determine that they were unable to participate rationally in the case, meaning they would be found incompetent to stand trial. Any attorney doing their job would recognize this and request an evaluation. Again, it's not about winning or losing, it's about ensuring the system doesn't punish someone who is not mentally capable of defending themselves. But this, folks, this is where things get difficult for attorneys. A client like this doesn't want an evaluation. They don't believe they need one. They may be highly intelligent, articulate, and deeply invested in their case, but that does not mean that they are competent. They cannot separate delusions from reality, and their refusal to acknowledge their mental illness is itself a symptom of their condition. As a defense attorney, I know what happens next. If I insist on doing the right thing and request a competency evaluation, I will face the client's wrath. They will turn against me. They will leave negative online reviews claiming I'm a bad lawyer. They may file a bar complaint falsely accusing me of misconduct. They will insist that I betrayed them, that I was part of the system working against them. Paranoid schizophrenia. And the public, you guys, you'll never know that I fought for them when no one else would. This case had two possible outcomes, the harsh reality, right? The case could go one of two ways. If I stand firm and I request a competency evaluation, the court will likely find them incompetent to stand trial. The criminal case will pause and they may be placed in some sort of treatment or mental health program. Not jail or prison, but a program. This would be the best outcome because for their well-being, even if they don't realize it, if they're incompetent for a year, the case gets dismissed, 5 years on felonies. If they go to another lawyer, the competency issue may not even be addressed. The client still deep in delusions, with self-destruct in court, refusing to cooperate, making bizarre arguments, alienating the jury with erratic behavior because they can't stand track. They will likely be convicted and incarcerated, where their mental illness really just goes untreated. This would be the worst case scenario. The biggest tragedy in cases like this is that true mental illness can look eerily similar to true innocence. Both refuse to accept the system's version of events, right? Both insist that everyone else is wrong. Both reject the idea that they need help. So how do we tell the difference? How often is mental health mistaken for stubbornness? How often is true innocence mistaken for delusion? The truth is we don't always know, and that's the terrifying part. Some people say people don't talk about this side of criminal defense. The public assumes that attorneys abandon their clients out of greed or disinterest, but the reality is far more painful. The very people we work hardest to help are often the ones who go out of their way to ruin us. A lawyer who fights for a mentally ill client for competency will be seen as the enemy. A lawyer who tries to get a case dismissed on mental health grounds will be accused of incompetence. A lawyer who endures the abuse, the insults, the complaints is rarely ever thanked. And yet we do it anyway. We make the effort because sometimes, all the time, doing the right thing means taking the hardest path. It means withstanding the anger, the mistrust, and the accusations, all in the hope that one day the client will receive the help that they truly need. This is the hidden burden of a criminal defense attorney. This is the reality of working with mental illness in the justice system, and this is just one moment in a much larger fight, a fight to balance justice, ethics, and compassion in a system that too often fails to see the difference between illness and intent.